welcome everyone today to this colleague. I am very grateful to the von Humboldt Stiftung, of course, to have had this opportunity to organize an event in presence, although not entirely. The hybrid, this new concept, is the best we can get at the moment, so we decided to take it with Professor Jeßberger. It's a challenge. Hopefully everything will go smoothly in the next 3 days. So I want to say to the people that are not able, that we were not able to host in Milan personally, that we are sorry not to have you here. There are many that I hope are now connected via Zoom with us, and I really would like to thank them all for having agreed and having taken this invitation. That also co-sponsored the event, and of course the Humboldt University, the Juristische Fakultät, and also the Italian Ministry of Justice, which gave us the patronage. And I also want to thank again Maria Crippa, who I guess all of you got to know in the past weeks and months, because she worked really hard for the organization of these Congress, not only for organizational things, but also really a lot helping us in designing the whole program. And also thank you for Giulia, Lavinia, Martina for your help in these days. So a few words on how the whole idea of having this colleague started, by observing the reality of our respective countries, Italy and Germany, which have a common legal tradition, a long history of dialogue and exchange among scholars, in particular in criminal law, are still very close for many aspects, but currently find themselves very far away with regard to their respective roles, in particular vis-à-vis the implementation and enforcement of international criminal law. And while Germany adopted the Völkerstrafgesetzbuch, so the Code of Crimes under international law in 2002, in parallel with the entry into force of the ICC statute, actually to be precise, one day before, Italy is still missing the appropriate legislation. With delay in December 2012, Italy managed to pass the Procedural Law 237 to implement the ICC in the ICC statute in our legislation, but never followed up with the substantial legislation which is needed in order for Italy not only to cooperate with the ICC, but also to conduct its own criminal investigations and prosecutions into these crimes under international law, namely war crimes, crimes against humanity, and genocide. In an article published 9 years ago, Flavia Lattanzi was already explaining very well while the execution law of 1999 that was issued together with the law authorizing the ratification of the Rome Statute in Italy is not sufficient to provide Italy with the instruments needed for the Italian state to observe its international duties that follow the ratification of the Rome Statute. At the same time, the ICC cooperation law, this one of 2012 that I was mentioning, needs as a pre-requirement that the internal system already implemented the provisions criminalizing the crimes under the jurisdiction of the court, as these provisions are not self-executing. And this is particularly valid in a system based on a strict legality principle like the Italian one, but also, of course, this was valid for the German one. The Italian delay is striking, remembering that even Italy hosted the big diplomatic conference in 1998 in Rome, and that Italy, together with Germany, worked within the group of the so-called like-minded states to see the ICC become the reality. In fact, by now, most, if not all, of these states have adopted the required legislation, and the debate in these countries in 2021 is focused on the evaluation of what has been achieved in the past 20 years of domestic implementation of international criminal law. What works, what does not work, what needs a rethinking, and which amendments shall be discussed. This is the current stage of the discussion in Germany. Here in Italy, however, we remained far behind, notwithstanding the many attempts and drafts at many levels, governmental, parliamentarian, including some important private initiative as the one led by Professor Pocar, who will give us his keynote right after our introduction. All this is to say that many capable, knowledgeable people have worked in the direction of a domestic implementation of international criminal law during the past 2 decades in Italy. And it is not a matter of lack of resources, not a matter of lack of interest or skills. So it is not a secret that we see this conference also as an opportunity to bring together many knowledgeable people, not only to discuss scholarly, relevant topics, but also to revitalize a debate in Italy and inflate new life in projects that have been remained in the closet for too long. At this point, given the accumulated delay, we can even benefit from the experience of other countries. For instance, we can already take note of the failures or those obstacles that have been encountered in implementing international criminal law in other countries like Germany, but not only, and try to be already a step forward and foresee these obstacles that others have faced, thus avoiding the same mistakes, maybe. So what is clear is that we urgently need to fill this gap. Clearly, the system that was designed in Rome can only work if every state shares the burden and becomes active in investigating and prosecuting the crimes under international law that are under the ICC jurisdiction. It is an integrated system, and it needs to function in all its parts with the common goal of closing the impunity gap. All this has been affirmed solemnly in the preamble of the Rome Statute in 1998, but of course the origins of the whole idea are much older and can be traced back to Nuremberg. And by the way, precisely in these days, we celebrate the 75th anniversary of the Nuremberg judgment, which might be just a nice coincidence, but we take it as a good sign. And I leave it to Florian. Thank you.
Yeah, thank you very much, Chantal. Welcome to everyone. It's a pleasure to be here. It's quite exciting to see real people again, even though unfortunately I see many masks, but I think that's the privilege of sitting here, I assume, in this university. Thank you very much for coming and for joining us in what is probably an adventure meeting during these times. So, yeah, it's a pleasure to be here. Also to meet a large number of old friends and of distinguished colleagues here from Milan and from other places around Italy and around the world. Of course, I'm most grateful to Professor Meloni and Maria Kripa and the whole team here in Milan who put all this together, and my contribution was obviously very remote, but I'm very happy to be here now to have the privilege of listening to all the excellent speakers we have in this quite rich program. So international lawyers, criminal lawyers, practitioners, academics, and many of them obviously connected to the Humboldt Foundation, either as fellows in Germany or former fellows in Germany or vice versa. So by way of introduction, a few notes on our topic. So our topic is domesticating international criminal justice. And, well, actually, on first sight, this sounds a bit outdated, as also Professor Meloni already mentioned. We all remember the years around the turn of the millennium with the Rome Statute being drafted and entering into force, and the question, what do states have to do in this time 20 years ago, beyond cooperation with the court, but in order to make themselves fit for making an effective contribution and allow for the prosecution under their domestic legal orders. And in fact, as we all know, as you all know, in many states, legislators took this as an opportunity and adapted their domestic legislation, in particular the substantive law provisions, in the early 2000s. And indeed also academically, this area has been treated by a number of comparative studies, just to mention the 2 volumes edited by Professor Lattanzi, co-edited by Professor Lattanzi, the Rome Statute on Domestic Legal Orders in 2000, and a series of books published by the Max Planck Institute in Freiburg on the national prosecution of international crimes, published between 2003 and 2006. So why come back to the issue 20 years after? So I hope you will agree with me that there are actually reasons why it is useful and helpful and necessary even to revisit the issues which we will discuss here at this conference, and why the topic is indeed topical and addresses current issues. So there are current challenges which are an urgent need to be analyzed and discussed beyond the fact which Professor Meloni stressed, and that is the specific Italian perspective on the implementation or domestication of international criminal law. So just 3 reasons why it could be useful and why it is necessary. So the first one is the normative one, the classical one. It is clear that domestic prosecutions of crimes under international law are vital to the current system of international criminal justice, which, as we all know, is a decentralized system of administration of justice. As you know, the Rome Statute explicitly acknowledges this idea of decentralized administration of justice, and even after the establishment of the ICC, the indirect enforcement of international criminal law through national courts remains the backbone of international criminal justice, also in numbers, not only as a theoretical point. So the second reason, so this may be something like a normative traditional approach to why it makes sense to look into our issue. The second reason, or a second reason, may be a more practical one. So the past 2 decades have shown, I believe, that international institutions indeed do their job, but there are limitations, there are restrictions in terms of their mandates, in terms of resources, in terms of the political will within these institutions and the states on which these institutions are ultimately based. So if we look at what happened during the past 20 years on the domestic level, and we will have a lot of chance during this conference to go in much more detail, we perhaps see after an initial euphoric phase, we saw a backlash, but then after, in the recent years, I think, we see again on the domestic level a certain increase in some countries, in particular in Europe, regarding prosecution of crimes under international law and prosecution under universal jurisdiction. And the third reason why it may make sense, and I think it makes sense to look into this topic again, if you want so, is that, as Chantal Meloni already mentioned, we are now in a position to critically reflect upon the experiences of those countries, of those states, where, in particular, substantive international criminal law has been implemented some time ago, and we can, and I think that's useful, we can take stock and revisit the issue in the light of these experiences, the shortcomings, the trends, perhaps the gaps and the debates we see not only in Germany but in many other domestic jurisdictions. So I think, and I hope you agree with Chantal and me, that it is indeed useful to discuss these issues again, if you want so. So before we start in a minute, and I'm very much looking forward to the first keynote by Professor Bocard, before we start, let me share a few very brief, rather general and tentative observations on some of the concepts, some of the terms, and some perhaps of the necessary distinctions which may shape our debates through the coming days. So it's about obligations, options, and obstacles, which you also see as the title of our brief introduction. So first, obligations. Of course, a fully fledged taxonomy of obligations in our context should at least distinguish by direction, positive obligations, negative obligations, by source, international law obligations, obligations under domestic law, under criminal law, under constitutional law, such as inter alia fair labeling, as we know, for instance, in the common law countries, by content, obligations to prosecute, obligations to criminalize, obligations to establish jurisdiction, and so on. And I think it's crucial to keep these distinctions in mind during our conference, and we will, I think, come back to them. I don't have time now to really go into detail, so just let me simply state one of the major obligation or non-obligations we see, and unlike the majority of treaties in the area of transnational criminal law, the Rome Statute does, at least to the majority opinion, not explicitly establish any obligation regarding the incorporation of the statute's substantive criminal law. And I'm sure we will discuss this position during our conference. So state parties, at least to this majority view, are not obliged to enact criminal legislation or even copy the Rome Statute if it comes to substantive provisions. So states or state parties retain their autonomy. Same holds true for universal jurisdiction under international law. So while there is an authority, I believe, to exercise universal jurisdiction with regard to certain crimes under international law in particular, so an authority under international law, there probably is no duty to exercise universal jurisdiction in the absence of very specific links. What is important and what is relevant, I think, from the international law perspective for our topic is, even though there may not be a strict obligation in the technical sense, it is in line with the spirit and with the plan and with the idea on which the Rome Statute and the whole system of international criminal justice is based. So the idea of division of labor and a clear objective to provide for accountability. So it is in line with this spirit to adapt the substantive criminal law of those states who want to contribute to this system. So there's encouragement, I believe, from the international level, but perhaps not a strict and technical obligation. Secondly, options. So probably states have discretion to decide not only if, but also how to adopt substantive international criminal law into their domestic legal order. Certainly, international law, constitutional law, in particular the principle of legality, which is more or less equally strict understood in Italy like it is in Germany, so this plays a key role, and other principles of criminal law form a framework which limits the number and type of available options, but there are different options, I believe, on how to implement and how to domesticate, if you want so, international criminal law. So this holds true as regards the format and the mechanism of implementation. So there may be complete incorporation, even copying, as we see in some jurisdictions. There may even be non-incorporation in a way, like this is the situation in Italy right now, more or less. And there could also be a modified incorporation, probably the way the German legislature, the German government went, by creating a specific piece of legislation, taking up the substantive provisions of the Rome Statute, but modifying them according to the legal constraints, but also to the criminal policy needs existing in Germany. But this discretion holds also true as regards the contents of implementation and domestication. So if the definition of crimes are implemented, usually they are the core of any implementing legislation in the area of substantive criminal law. But for instance, there are further questions there. For instance, like what the German legislator did, whether the national implementing legislation in some parts goes beyond the Rome Statute's provisions, for instance, taking account of customary international law, which today may have emerged, but there was no consensus perhaps in 98. Another issue in that regard regarding the contents of implementation would be if and which general principles of criminal law are implemented and added to the normal, to the regular, to the ordinary general principles applicable in criminal law. And finally, this is a debate we had in Germany recently, the issue if and to what extent specific procedure rules should be part of this implementing, domesticating project in a certain jurisdiction. Procedure rules which may support the adjudication of crimes under international law in this specific domestic system. So I just leave all this on the table, and we will certainly come back to that during our conference. So thirdly, and very briefly, obstacles. Of course, obstacles, this is a huge topic, and in particular, given the experience we had in Germany and in other countries where there were prosecutions on the basis of implementing legislation, there's a lot to say about obstacles. So these obstacles are manifold and diverse as the options, if you want so. So, for instance, obstacles may result from a lack of legislation in the area of substantive law and defining specific crimes. Obstacles may result from procedural bars. If you just think of the still ongoing debate in the International Law Commission on the exceptions of functional immunity, which to many working in the area of international criminal law in the domestic systems came quite as a surprise that there still is an open question in the International Law Commission. So this issue, what kind are and are there any procedural bars? These may form such obstacles. And obviously, obstacles may result from a lack of political will to prosecute certain crimes, in particular crimes of the powerful states, of powerful corporations, and so on, often connected with the issue of resources given into the system, given into those in charge of prosecution of these crimes in the domestic system. And so the issue of resources, the issue of building capacity, knowledge, but also technical capacity to be able to apply this implementing legislation. This is one of the big issues, and this may be one of the big obstacles to effective prosecution in the domestic context. So obviously, and this is something already Professor Meloni stressed, our conference builds around a certain debate here in Italy, and the idea of revitalizing this kind of debate with a view to perhaps implementing substantive international criminal law into the Italian legal system. And obviously, if you look in the program, the fact that a number of scholars from Germany attend this conference, and I'm very pleased that they do so, the German experience plays some role. But it would be a complete misunderstanding, and I'm sure you're aware of that, that Chantal Meloni and myself organized this event to simply suggest that the German solution, that the German legislation should be in any extent copied or taken over to Italy. It's rather that we believe that there is some experience, also very critically to reflect experience we have in Germany, which in addition with other experiences in other domestic systems, when we have a panel on the global perspectives, may be useful to inform the debate which we aim to revitalize, as Chantal puts it, here in Italy. And so the aim and the idea, and this is why it's so great that we all can meet in presence here, or at least some of us can meet in presence here, is to create a space for us, for scholars, for practitioners, to exchange and discuss these ideas, to discuss perhaps lessons learned from domestic experiences in countries around the world, and perhaps to develop a way forward. So I do very much look forward to this exchange, and now hand over again back to our main host, Professor Chantal Meloni. And it's a pleasure to be here. I look forward to the discussions. Thank you very much.